There we go. Okay. Good evening and welcome. My name is Brenda Considine. I'm going to be hosting tonight's presentation. Tonight, you're joining the Alliance of Private Special Education Schools of North Jersey. This is the last of our 9-part workshop series that we host this academic year. We sort of took our conference and unpacked it. So we do one workshop, one night each month, and tonight is the final one for this academic year. Tonight, you're joining us as we talk about securing the future for your child with special needs, financial and estate planning. We're joined tonight by Paul Pryor and Don Brown. Paul is the brother of a man with autism and is the partner at Hinkle, Pryor and Fisher, a law firm specializing in disability law. They have offices statewide and a long and very proud history of serving our community. So we thank Paul for joining us tonight. We also have Don Brown. Don has been in the financial services industry for more than 30 years and has earned the Chartered Special Needs Consultant Delegation designation. Don is back for an encore performance. He has presented with us before, and I promise you will not be bored tonight. Even if you think you don't understand this content, it feels lofty and a little bit out of reach, Paul and Don will make it accessible and, yes, actually fun. So get ready. I'm going to introduce you first to the Alliance so you can learn a little bit about our work. The Alliance of Private Special Education Schools of North Jersey is a group of 40 state-approved private special education schools. Children attend at no cost to parents. They are placed by their sending district at our member schools. Our schools are really committed to making sure that families have information that they need in order to access the special education system in New Jersey. I'm going to share my screen with you so that you can see our website. We provide services and supports to anybody. We don't care if you're in one of our schools or not. But if you are at a place where you are looking for information, there's advocacy and support resources, information about least restrictive environment. And if you're looking for a school, our school finder feature can help you or your child study team look for a program in North Jersey. Our search feature, my goodness, it takes us all the way out to Massachusetts. Our search feature allows you to search by age, disabilities served, and counties served, and generate a list of schools that might be a good fit for your son or daughter. We also have an advocate who can help families and school districts as they start to look for a program. So with that, I am going to admit these last two people and then invite Don to get us started.
Very good. Wow, I feel more pressure than ever with that introduction. I don't know about you, Paul.
Absolutely. That is hard to live up to. So
we will do our best. It says I can't start screen sharing until
I stop. That's not
correct.
Good. Okay. Hold on just a second.
No worries.
Why isn't that opening? Okay, somebody pause for me. While we undo that.
Okay, while you do that, we can still do audio. So first, for those of you that are joining us, thank you for sharing time with us. We know how precious your time is. Part of the reason Paul and I want to do these together is we want to make sure that in the space of an hour, we provide you with information that you probably could not get anywhere else. Paul speaks in many, many places. I'm happy to speak in different places around the country, but it's a rare opportunity that we get to present together so the people that are in our audience today get to see both the financial side, the legal side, and how they practically connect. So I'm always honored to work with Paul. He knows that every time we deliver a workshop, we have a couple ground rules and we got 3 fundamentals that we want to follow. Our ground rules are pretty simple. If you have a question, please feel free to type it in the chat, or please feel free to unmute yourself. You've come here to learn something, so number one, we want to deliver on that. Number two, we want to give you at least one actionable item. I think we got it, right?
Sorry about that.
No worries. Okay, we want to give you at least one actionable item where you can say, glad I was there. And then lastly, we want this workshop to be interactive. We know people talking at you sometimes can get overwhelming. We're going to ask you questions. Again, you can type the answer in the chat if you know it. And we'll ask Brenda to kind of monitor that for us on the way, or if you want to unmute yourself. The idea is we want to have some fun and possibly give away some cash and prizes if you're paying attention. So here's the title of our presentation: Making the Future More Secure for Your Loved One with Special Needs. Both Paul and I approach this from the unique perspective that most of the things that you've done for your loved one with special needs required a battle or a search without a lot of support. Here's two areas that are vitally important to both your peace of mind and security, and the quality of life and lifetime of care for your loved one with special needs, where now we can combine those two sources together and you can walk away in the space of an hour, hopefully with one of the more valuable hours you've spent recently. And here's what we're going to do. We're going to answer the question, what's important to you as a caregiver? We know that as the parent, sibling, loved one, guardian of a loved one with special needs, you do things every day for your loved one. And we describe that as you're doing it unconsciously competent, meaning from the time your loved one wakes up till the time they go to bed, you're doing things for them automatically. Why? Because you know it needs to be done. But we also know that there's going to be a time, and we jokingly say, probably 2 o'clock in the morning when you can't sleep, when you start to think of, well, what's going to happen when you're not around? So in the space of an hour, we want to talk about 10 steps that every family will walk through chronologically, or probably should be addressing, to combine the special needs dependent and loved ones planning for when you're no longer there. Fair enough? So step one is plan for the future. Now, that may seem kind of obvious, but we also know that many families don't plan, and it's not their fault because nobody's shown them how. So when we talk about a plan is not hoping that a loved one or a sibling will step in when we're no longer there. A plan is not waiting for laws to change for things to get better. A plan is something that you actively put together to make sure that you get the outcomes that you would like, and to also take advantage of the things that are out there that can make your planning better. Paul, you want me to add anything here or keep going? I timed it perfectly, didn't I? I apologize. So if we're talking about having that plan for the future, let's talk about some of the important things that you're going to want to have in that plan. The first one says medical treatments. We know when we're talking about your loved one with special needs, everyone is unique, everyone's different, and the amount of treatments they need or require, we know it spans everything from medical to behavioral to societal, all of those things. But the longer you think of those things in advance, the better your planning can be by making arrangements in advance. As we're going through this workshop, as Paul and I are talking about both the financial things and the legal things that you should be putting together in a successful plan, what I'd ask you to think about is the long-range plan for your loved one with special needs. Where do you see them as adults, and where do you see them when you're no longer there? Brenda, this might be a good spot to put up the poll.
Sure. So we have the opportunity to ask you guys some questions. We just want to know who's in the room. Are you a parent? Are you a sibling? Are you a professional in the field? And how old is the person you're here for? How old is your family member? So you should see that poll launched. And if you could just let us know who's in the room, that would be fabulous. We'll give that just a minute or two. In the old days, we'd have a show of hands, or we'd have, people talking about it over at the coffee station. So we've got to update our ways of getting to know each other.
Technology is a wonderful thing when it works.
Yeah, I guess. So right now in the room, we've got 92% of our guests are parents. We've got 6% siblings, 6% professionals in the field, and 3% other. And we left this poll question open-ended for those of you who are quick with math. There's an option for you to select both. So we may have some family members who are also professionals in the field. We asked a little bit about how old your family member is. 41% of you have children under the age of 10. Oh, 16%, I'm sorry, have kids under the age of 10. Almost half of you, 47%, have a family member between 11 and 17. And 36% of you have kids, young adults, 18 or over. So that gives us a sense for who's in the room. I've always said it's never too late or too early to start this kind of planning. So it's nice to see everyone here.
Absolutely. And to your point, the earlier you start to consider these things, the easier the long-term results are to accomplish. And typically the less expensive accomplishing those results will be. When we get into the meat and potatoes of having to combine the two things together, we'll talk about how those things work. So when we're talking about that plan for your future, the medical treatments we talked about, behavioral treatments, et cetera, what do we need for supports? Second area is education. For those of you that have special needs loved ones that are under the age of 18, currently, all of their supports are going to come through the Department of Education. For those of you that have a loved one attending one of the Alliance schools, you're already familiar with how that process works. But when that individual turns age 21, what happens after that? What happens after school? Will they go to a post-secondary education, a supportive environment that has a special needs program? Will they go to a work program? Will they go to a day program? All of the things that you would consider you would want to have in your plan, because the supports and resources that you may want to put in place to make sure those things happen can be in your plan and have those better outcomes that you're looking for. And lastly, where will your loved one live? Do you plan on having them living with you as long as possible? Do you plan on having them live independently or semi-independently? I think Paul and Brenda would agree some of the big improvements and some of the more exciting things that we're seeing are happening both in adult employment and in the housing sector. But many of those things are happening where they're hybrids. What I mean by hybrids is it's not all public, it's not all private. Sometimes it's a combination of the two. And being able to know what you want for your loved one and being able to plan to have the resources available in the manner that you need them available becomes critical. So we said we wanted to give away some cash and prizes, and we want to get you involved. So those of you that have children under the age of 18, you may or may not know this. Those of you that have special needs loved one above the age of 18, you will probably know this. So the first one to answer either in the chat, if Brenda will monitor the chat, or if you want to raise your hand or unmute yourself. And here's the question. What is the maximum amount of assets that an individual can have in their name and qualify for Medicaid support? What's the max amount of assets an individual can have in their name and qualify for Medicaid? And Paul's not allowed to answer.
All right. So, oh my goodness. In the chat, we've got Anne saying 2,000, Grace saying 2,000, Yvette saying 2,000, Jamie saying 2,000.
So Anne was first, and Anne's right, it's 2,000. So Anne, either in the chat or if you're willing to unmute yourself, we're going to let you pick either a quick pick scratch off ticket where you could win up to $10,000 really fast, or you can get a Powerball ticket, which I believe may be more than 100 million if you win the big prize. So Anne, which would you like?
Can you hear me?
I
Yes, you
can. We can hear you, Ann. Hello?
Oh, we could hear you for just a second. Anne, if you want to just make a note in the,
We lost her.
Ball.
lost
This
her.
is Powerball.
Well, okay, she says her Powerball is wonky. She wants Powerball.
Powerball. Okay. Now, we just have a very simple moral obligation. If you win the big money, you are morally obligated to hire Paul and I as your exclusive legal and financial advisors. Is that fair, Ann? Okay. More importantly, though, we want to keep you engaged. We want to be able to have some fun, but I don't want you to lose sight of the irony of what we just did. We don't want you to leave your planning for your special needs loved one to chance. So, as we correctly identified, maximum amount of assets an individual can have in their name qualify for Medicaid is over $2,000. Now, why is that important? For those of you that have younger children and don't know this yet, when your child ages out of the school system at age 21, the delivery system for all of the adult supports now changes, and the overwhelming majority of those supports are delivered through Medicaid. If you never heard of that before or weren't aware of that, and you thought, well, Medicaid is health insurance for those that can't otherwise obtain it or don't have the income. When it comes to special needs services, again, the overwhelming majority of services are going to be delivered through Medicaid. What does that mean? That means your loved one with special needs needs to be Medicaid eligible. What does that mean? No more than $2,000 of assets in their name. Therein lies the first hurdle of special needs planning for our loved ones. How are we going to have them have the level of independence that they can achieve, have them have the quality of life that we want them to have, yet they can only have $2,000 of assets in their name? So in Paul and our practice, we teach people how to effectively use the ABLE account. If you're not familiar with the ABLE account, it's probably a tool that, with rare exception, most families should have in their planning for a myriad of reasons. Brenda, in the future, if you'd like us to do a workshop just on ABLE accounts and special needs trust, Paul and I'd be happy to do that as well.
Thanks.
But think about something. And this happens way too often. Paul's office probably gets emergency calls. I won't speak for him, but probably more often than we care to see, which is this. There is a loved one with special needs who's now an adult, and suddenly assets come into their name that are over $2,000. How does that happen? Take a look at the screen. Things like inheritances, things like life insurance benefits, retirement plans from your employer. We've been doing this for 30 years, as Brenda said, and part of our work is to do employee benefits for organizations that serve you, legal organizations, the schools, the medical and support vendors. So we do these all the time. And we know that when you have either group life insurance through your employer or a group retirement plan for your employer, you're going to name a beneficiary. It's not a surprise to most people. What most people don't realize, however, is if you do not name a contingent beneficiary and your primary beneficiary dies without you changing it, or if primary beneficiary and you died in a common accident, then the contingent beneficiary automatically becomes your children equally. So without any planning, think about the disaster that happens. Mom and dad pass away, insurances get left to children equally. Now your loved one, who quite possibly could be living independently, happily in assisted living, happily doing a work program, suddenly gets removed from all of their benefits. And as Paul's team will tell you, as we will tell you, there's only two things that solve those issues, and it's time and money. And if you as mom and dad or guardian are not there to oversee it, you can imagine the disaster that incurs. So when we talk about giving you an actionable item, here's your first actionable item. You can call your insurance company, your employer, your human resources department, and your retirement company, and you ask for a change of beneficiary form. And what you want to do is you want to update your beneficiaries. Primary can be the same as you already have, but now contingent beneficiary needs to be someone or some identity that is not your loved one with special needs. And what we're going to talk about is the ideal solution for that, which is a special needs trust. Brenda, any questions so far? Are we good?
Nope, I'm just going to put that in the chat. We do have a couple people saying I'm right in the middle of that right now. I've got money for my son and don't know what to do with it. So I'm sure you're going to get to that. But people,
yeah, we'll talk about those things at the end of these conversations. Because you've invested time, both Paul's firm and my team will happily have an initial consultation with you where we'll answer all your personal questions as we go along or at the end of the workshop. Paul and I will stay as late as 8:15 to answer any questions you guys want to share. The greatest thing about these workshops is we learn from each other. So now, if you want to learn for an ABLE account, for example, Brenda, if you would type this in the chat, if you don't mind. There's a website you can go to. It's called ablenrc.org. It's a national resource center for ABLE accounts. You can go back as often as you like. It's run by a nonprofit organization, so nobody's going to steal your information or try to market to you. And until Paul and I get to do that workshop for you, it's a great place to learn about ABLE accounts.
I'm sorry, ABLE NRC?
Yes, ABLE-NRC. It stands for National Resource Center, ablenrc.org.
Corrected. There we go.
Now, step 3 says family meeting. Now, what do we mean by having a family meeting? We all recognize, Paul will be the first one to tell you, when you have a special needs loved one in your family and we're raising those children, it's a family affair. Everybody understands what their roles are, what their responsibilities are, who's going to do what. But when we're answering the question, what's going to happen when I'm gone, that family meeting is imperative. You cannot hope that a sibling is going to step in and become guardian, caretaker, trustee without any preparation, without any planning, and expect that to be a successful outcome. If you have children with special needs and they have siblings and you want or hope that sibling is going to step into your role, then number one, you need to make sure that they're going to be physically able. Maybe they're not going to live locally. Maybe they have their own family. Number two, you want to make sure that they're financially able. Are you able to provide the resources that would be necessary for them to take on those responsibilities? And lastly, are they going to be what we call socially and geographically able to do that if their lifestyle and living is far away from where your loved one with special needs is living? So at the end of this conversation, we're going to give you a tool that can help you prepare for that and make that meeting much more successful. But I think we would all agree that that family meeting is imperative if we want to have the future generation, siblings, other loved ones, or family members know what our intentions are and what we're going to ask of them to do. Step 4 is create a team. You're kind of doing that already. And again, thank you for attending this workshop. Let your friends know they missed a good one because you have both legal and financial in one spot. But what I want you to envision is I want you to envision your loved one with special needs. And there's a table. And around that table are all the people that you see: financial professionals, educational, attorneys, caregivers, medical, and all of the social and nonprofit organizations that will serve your loved one as an adult. Now, what I want you to consider is all of those people talking about one thing, which is the quality of life and lifetime of care of your loved one with special needs. While we cannot create that board meeting in a single meeting, you as the person who understands that can help coordinate all of these things. And Paul and I are the professionals that can help you do it successfully.
We've got a couple of questions. One person says, what if there's no other family members willing to step in and do that?
Great
Paul, you're
question.
going to tackle that?
Sure. Look, if you have a family member who can step in to act as trustee, and a trustee is a person who manages a trust, invests the money in this trust, and spends the money out of the trust, generally with some professional financial assistants or advisors by their side, which is always a good option. If you don't have that person, because your child with special needs is an only child, or perhaps the neurotypically developing sibling has some of the considerations that Don was mentioning a few moments ago, or just for other reasons is not an appropriate trustee. There are organizations and financial institutions out there that can step into that role. I mean, you can employ or designate a financial institution or a trust company, a for-profit entity, to manage the money in the trust and spend the money out of the trust on behalf of your child with special needs, adult child with special needs. Or there are various nonprofit organizations out there, often referred to as community trusts. And there are several community trust organizations in the state of New Jersey. Plan New Jersey is an organization that comes to mind as probably the oldest and the largest community trust organization. They are a nonprofit organization that provides many of the same trustee services as a for-profit trust company would do, but they tend to have a specialty in serving the special needs population, those with mental health diagnoses, as well as intellectual developmental disabilities and other types of disabilities. Plan New Jersey certainly isn't the only one. There are various ARC organizations out there, like the ARC of Bergen-Passaic County, the ARC of Sussex County, and so forth. So if you have someone in your life that you need a designated trustee for, someone to manage those funds after you and your spouse or the adult child's other parent is gone, that is a resource that I would look to first. And Don and I think both have worked with Plan and other similar organizations like them over the years. The wealth of knowledge and support.
Absolutely. And we'll talk about some of the differences between guardians and trusts and responsibilities a little bit later. But before we move further, this is probably an excellent place to put this out there. And forgive me if I'm being Captain Obvious here, but the questions you guys are bringing up are excellent ones. And if they're not addressed, then think of what happens. It's called crisis planning. Mom and dad passed away, didn't name a guardian, didn't name a trustee, or didn't set up their trust. And now families are scrambling, and there's a lot more court time involved. There's a lot more stress. There's a lot more expenses involved instead of advanced planning, which will always lead to better outcomes. So
we've got a question here. Someone says, I've got a special needs trust, but I don't understand it. How do I go about getting money into it?
Okay, I'm going to say this. Hold that question. If Paul and I haven't addressed it completely by the end of this presentation, ask us again.
Okay.
And I'll tell you two things to directly answer your question. Number one, that's what we will teach you. How to use it, how to fund it. Number two, if you have a trust and don't understand it, Paul's office is your first call to make tomorrow morning.
And if we wrote it, we'll gladly explain it again. So
there you go.
We've got a few more questions, but I'm going to copy those and we'll ask them in just a few minutes. Go ahead.
You got it. Okay. So again, getting additional support, I congratulate you. You're here. So you're already taking part of that. But now the next support level are going to be government agencies. So before we go to the next slide, here's my next question for those that want to participate. It's not an easy one, but I think you can do it in the chat. The question is, who can explain the difference between SSDI and SSI? Anybody know how to explain the difference between SSDI and SSI? Paul will come back to you.
I feel like Hermione Granger here.
So we've got folks answering things in the chat.
Excellent.
Really nice. SSDI is for people who are already working and became disabled. age difference. SSDI is for those who work.
Yeah.
SSI is for those who are disabled from the beginning. SSI
Okay.
is income-based, whereas SSDI is more based on age.
Yeah.
Both are
All right answers and all good. So first one to answer was who, Brenda?
first one who answered, wow, is Jamie.
Jamie, would you like a scratch off fast money or a Powerball big money chance?
Scratch off, she says.
Jamie says scratch off.
Scratch off. There you go. See, we're learning about you. It's fast money you want. That's good. But the point just made is an excellent one. SSDI, as you guys properly answered, is based on our own income. If we have a long-term disability that qualifies for Social Security disability, we will receive financial assistance that's based on our work record. SSI, supplemental security income, is designed for those adults that do not have a work record or quite realistically may never be able to earn enough to earn SSI. So consequently, SSI is designed for basic food and shelter. Now, this is a good place to touch on this for a bit because in a chronological order, your loved one is going to hit age 18. At age 18, they're adults. And in the eyes of the law, now all of their benefits are needs-based based on their resources, not mom and dad's. So at the age of 18, if you don't know, you're able to apply for SSI. And SSI begins to provide basic food and shelter. Now, for a few minutes, I'm going to touch on, and I'd like Paul to elaborate if he has any further information on this process, because we see mistakes happening way too often. And here's the mistake. You apply for SSI, but you don't tell SSI that you're either going to charge your loved one rent or your loved one with special needs as an adult is going to pay their fair share of food and expenses. Now, if you say, well, of course, we're going to have our loved one live with us. We've always done that. Then Social Security will reward you by reducing your benefits by up to a third. It's known as in-kind support. So if SSI is designed for basic food and shelter and you're providing it for free, then Social Security is going to thank you by giving you less. And I think we'll all agree a couple $100 a month for long-range planning for your loved one can make a big difference over a long period of time. So before you do that application, be prepared. If you've done it and received a reduced amount, try to go back and get that restructured and try to maximize those benefits for two reasons. One, the obvious one, which is the financial support, and two is being able to qualify for SSI for what happens next. Paul, I miss anything of value?
No, you've got it right on the head. They call it in-kind support and maintenance, and it's considered income to the child. So the Social Security takes that income and reduces their benefits by approximately a third. You're 100% correct. Charging your child room and board, although it may seem awkward, and it may seem, a lot of parents sometimes react when I give them that same advice a little bit viscerally because they feel like it's unfair. But it's also unwise, in my view, to leave money on the table because those funds are there to benefit your now adult child with special needs. So you might as well take them. You've paid enough into the Social Security Trust Fund on your own. You might as well get some of that back for the benefit of your child. And you're not committing any type of Social Security fraud, or you're not in any way being unethical or untoward. It's there for a reason. And you don't want to reward the government by letting them off the hook.
Right. And again, I'll remind you, and Paul should probably talk on it because he's the one that taught me this. If your loved one with special needs becomes an adult, and nobody on this meeting would do that, but legally, if you drop them off at a police department or a hospital, no one could do anything to you legally. Paul, did I get that right?
Yeah, that's true. That is 100% correct.
So if you think about, well, imagine the amount of money and services and supplies that would now take, as opposed to the small amount of SSI benefits that you're receiving with your loved one living with you. So to put things in perspective, as Paul says, you never want to leave dollars on the table that could be used for your loved one with special needs. So now let's talk about the next step, which is Medicaid. And we mentioned earlier that when your child turns age 21, all of the services and expenses that are now paid for by the Department of Education, that delivery system changes, and it changes to Medicaid. So at the age of 21, now you will fill out an application to apply and qualify for Medicaid, and you will receive services. In New Jersey, it's through the Division of Developmental Disabilities, or DDD. But if you already qualify for SSI, you will automatically qualify for Medicaid. That's why it's important to be aware of it, maximize it, and have it in place for your child when they turn age 21. Paul, please add anything that I think is probably I'm missing.
Yeah, the other thing that you're going to want to do, and just as a practical matter, you're also going to want to apply to the New Jersey Division of Developmental Disabilities, DDD, around the time that your child turns 18. Because as you mentioned, those services that are delivered once the educational entitlement comes to an end are delivered through DDD and coordinated through and by DDD. So in order to get the access to those services, you have to be eligible for DDD services. So I highly recommend people apply at 18, even though in most cases people are going to receive services out of the division for another 3 years. I tell them to do so around 18 for 2 reasons. One, the division has a history of moving at molasses-based speeds. So they move very slowly in terms of processing applications and whatnot. And 2, if an application for eligibility for DDD services is denied after an application is submitted, you're going to want to file an appeal. And you have a right to an appeal, and you should pursue that appeal. Unlike in special ed land, when you have a dispute with your school district, where there's supposed to be accelerated timeframes which disputes are resolved, heard by the courts, which never are abided by anyway. And when you're appealing something with the division, it can literally take 2 or 3 years before an appeal is resolved. So you don't want to start the process when your child is a few months or a year away from aging out of his educational entitlement, have an erroneous denial, file that appeal, and then have it take 2 or 3 years to resolve, because what's going to happen is your child's educational entitlement will end and he or she will be sitting at home watching YouTube videos and eating potato chips all day. And that's not exactly the outcome that we're trying to achieve here. Again, we have to plan ahead and think about the long term. So.
Perfect.
Back to you, John.
I'm going to start whittling away at a few of these questions.
By all means.
In no particular order. Do you have to have a formal lease and declare the rent as income if you charge room and board?
You do not need a formal lease. No, you have to inform the Social Security Administration that you are charging a room and board. And then the second part of that question is more of a question for an accountant. But as an accountant has, and Don, chime in here if I'm wrong, as an accountant has explained it to me, and I make no warranty express or implied that this is 100% accurate. Consult with your own accounting professional. But rent is, yes, taxable to you. Room and board is not. So you may want to consider calling it room and board.
Okay, that was another question. You have to claim it on your taxes if you're getting room and board. So the answer to that is no if it's room and board, but maybe yes if it's rent.
Yeah, well, absolutely yes if it's rent.
Okay.
That I do know.
Right. And to Paul's point, you'd have to declare that rent as income and pay taxes on it as income. The amount you receive from SSI would probably more than offset it. From just a sheer practical approach and standpoint, having room and board is a more practical way to approach it. However, off the record, and I know this is being recorded, Paul, you can verify the maximum amount of SSI that someone will receive, particularly in New Jersey, is in the $800 range.
Actually, after the beginning of the year, it's a little over 900 now.
900.
A little over 900. Yep.
So again, I'm thinking strictly from dealing with Social Security and Medicaid and those government agencies, how difficult it might be. And we've heard stories, both Paul and I, depending on who you talk to at that organization, sometimes you get different results. So what I would magically suggest is that your list of room and board expenses total somewhere in the $900 range.
Absolutely.
Let me pitch one more here and then we'll keep going. SSI continues to ask me to repay what they paid out to me for my child. They said benefits are based on my income as opposed to my son's disability. Is this correct?
There's a lot in that question that is very fact specific. Remember, if the child is over 18, no, parental income and resources are not taken into consideration. If the child is under the age of 18, parental income and resources are taken into consideration.
Okay. All right, so we have more questions coming in. Oh, she says he's 3. So that's
Yeah, there may be fact specific reasons, and there may be ways to deal with that are very fact specific.
okay. So we've got more questions, but I'll pepper them in as we go. So let's continue. Thank you.
Okay, not a problem. That's great. All right. So as you're starting to realize, some of the things that you'll be doing are actions. Some of them are financial. And of course, the important underpinnings of a whole plan is the legal part. So for the next couple minutes, we're going to talk about the things that you would absolutely need in your estate planning, but I want to approach them from the way that we do it normally together. I'm going to approach them from the practical standpoint, and then Paul's going to make sure that I don't make any legal mistakes, and we do everything from factual so you get it. But let's ask a question. The question is a will. What is a will? So if you were taking notes and I asked you for a one-word definition for a will, what would your definition for a will be? And if you want to put your answers in the chat, give us an idea of your one-word definition for a will. You're muted, Brenda.
Sorry, we've got a plan, wishes, your affairs, wishes, protection.
See, I lost a bet. I always bet Paul somebody says security, and I lost that one. But those are great answers. Plan, wishes, and those are what they are and what they do. The easy definition that I never want you to forget, and estate planning, we want to make it simple so it never gets confusing in its concept. And a will is nothing more than a note, N-O-T-E. A will is a note. And we always joke, if you were going away for the weekend and you were asking Paul and I to watch your home or watch your family, you'd leave us a note, right? Here's where we're going. Please try to not call. But here's the neighbor's name. Here's the doctor's name. Here's where the circuit breakers are. And for Paul and I's sake, here's where the liquor cabinet is, as Paul always says. Exactly. But the idea is a will is a note and you're never coming back. So if a will is a note and you're never coming back, what's going to happen in a will? 3 things are going to happen. Number 1, who gets your stuff? Now, I want you to go back to that second slide that we talked about when we named beneficiaries. So if you have life insurance, whether it's group or individual, you have retirement plans, whether either at work or IRAs, those types of vehicles have beneficiaries named on them. So if you name in your will someone different than what you named on the beneficiary of those documents, the beneficiary takes precedence. So all of those things that you have that have a beneficiary do not have to go through your will. So a will says who gets your stuff. Second thing a will does is who becomes guardian of my dependents. Even in regular planning, we meet families all the time that they never do a will. because they never want to have the argument about who would be guardian for their children. They can't decide, or they don't want to have that argument. Well, when we have a special needs loved one and they turn age 18, if they need guardianship protection on any level, and Paul will expand upon that, then we need to make sure that we're addressing that in the will. And then the last thing a will does is it names the agent that you want to accomplish those things. It's called an executor for the most part. So remember, a will is a note. It does three things: who gets your stuff, who becomes guardian of your dependents, and who becomes the person that you're asking to execute those wishes. Paul, back to you.
Yeah, I mean, a will is that's a very good statement. It's a note. You're absolutely right, and there are a lot of components to a will. I mean, there are tax considerations, and there are appointing fiduciaries and people to execute and accomplish, your wishes that you've left in your note. But you're 100% correct. And what a lot of people do is they put this stuff off because they can't wrap their heads around who will do certain jobs. And the biggest one comes about who will be the guardian of my child. That's the one. You're absolutely right. I want my sister to do it. My spouse wants her brother to do it, and we can't agree. The problem is that in doing nothing, what you've done is create a great risk that if you don't write that note and you still go away on vacation, and Don and I still rate your liquor cabinet while you're away, and you get wiped out, in a glorious ball of fire together, what's going to happen is eventually the courts are going to decide all of these issues. And I hope there's no judges on this thing tonight, but you do not want to leave your fate up to somebody wearing a black robe and holding a little hammer in their hand, because the person that they pick may not be the person you pick. And they might actually wind up picking someone that in your wildest imagination, that you would never want to have any access to your funds, have any governing authority over your children. And you'll be rolling over in your grave, and there's nothing you can really do about it. So having the will is a basic cornerstone document in any estate plan. It's where everything begins, and everything else trickles out from there, including special needs trusts. You've got to get the cornerstone document put in place. I often joke that I do the unpleasant side of things, the talking about death, the setting up of these technical documents. Don gets the advantage of doing the warm side of things, about funding and all the happy thoughts, and how we create the money and wealth, etc. To actually
let's not make my job so glorious. We're still talking about that. Sorry. But now, many of you on this workshop may be familiar with Paul's firm, Hinkle, Pryor and Fisher. If you're not, they're one of the leading firms that we work with that do this type of work. So when Paul's talking to you about the things that happen, he's talking from firsthand knowledge in dealing with families. And what the cliches about an ounce of prevention are. When we're talking about your special needs planning, it could not be more true. So if a will's a note, now the next thing we want to talk about is a trust. And we're going to talk specifically about special needs trust. But before we do that, again, I want to make it conceptual so you never forget estate planning. A will's a note. So if a will's a note, someone give me a one-word definition for a trust. Will equals note, trust equals any guesses? Okay. That's all right. That's good. That means we're talking to the right folks. Now, if we're talking about a will being a note, Paul and I always talk about a trust being a cup, or what I like to describe as a bucket, because a bucket's bigger. So if your will's a note, your trust is a bucket to put assets in, that you want used exclusively for your loved one with special needs. And Paul and I know from experience, when we talk about trusts, many people kind of glaze over or kind of sound out because they think trusts are only for rich people or trust fund babies. When in reality, any family that has children and assets, a trust would help their planning. If you're a family that has a special needs loved one, a special needs trust is imperative in your planning. If you know anything about trusts generally pay beneficiaries for things like health, education, maintenance, and support. A special needs trust cannot say that because a special needs trust has special wording in it that Paul's going to describe to you. Now, why do we bring this up? Because if you're going to go through the process of planning, you can't cut corners and you need to do it right. We at Special Needs Funding Coach do not do the legal work. We are not attorneys. As Paul stated, we help you plan on funding that trust. But when it comes to doing a special needs trust, this is not the place you go back to your real estate attorney. This is not the place you go to your employer's legal program to get a discount. A special needs trust needs to be done by a qualified special needs attorney. And that's why Paul is here with us to talk about what a special needs trust is, what it does, and why it's so imperative to do one correct. Paul, I'm going to cough, so you can jump in if you have.
Is that my cue, Don? Yeah. So yeah, I mean, for years, and my founding partner of my firm, Herb Hinkle, always referred to as a trust as an empty cup. And I do like, Don, I like to use the word bucket because it's a bigger. So whether your vessel is a big bucket or a small cup, it is a device, and I just so happen to have a cup with me. It's by coincidence, and now it looks like a bucket because I get close to the camera. So it's all about perspective. A trust is a device that's going to hold assets. Generally speaking, after someone has passed away, but not always. And I'm going to elaborate on this a little bit. A trust is not, as Don said, something only for the wealthy. It is not a mahogany paneled, marbled floored financial institution. A trust is something like a cup that is created by some bald-headed lawyer or otherwise. Sometimes it's better to say that, a trust is nothing more than a piece of paper with words on it, right? Somebody drafts up this piece of paper, puts certain words on it. Trusts have their own name. They have their own tax ID numbers. They're created generally by parents, and they provide a set of instructions. This piece of paper provides a set of instructions about how the money in the trust is going to be used. So I create this bucket or cup by having a piece of paper drafted. And, in our case, parents sign that piece of paper. And the moment they sign that piece of paper, bam, a trust springs into existence. It may be the Smith Family Trust of 2023, Smith Family Special Needs Trust of 2023. As I said, it has its own tax ID number. And that, the Smith family says, this trust is for the benefit of our son, Robert, and I appoint Robert's sister, Sue, as the trustee of that trust to manage the money, invest the money, spend the money over the course of Robert's lifetime. Not all trusts are special needs trusts. And just because somebody says they have a special needs trust and it was drafted by someone who maybe doesn't do a lot of special needs planning, doesn't make it a special needs trust. Special needs trusts have to have certain sort of magic incantations as part of the language that's contained in the document. There's a number of them, but the primary magic spell that has to be in this document is the document needs to make clear that the money is for the sole use, in our example, of Robert, and that the money in that trust cannot be used to pay for any good, item, or service which is already provided for by the government through government assistance benefits, DDD, Medicaid, SSI, Social Security, etc., housing assistance, and so forth. But the trust can be used to provide supplements or to enhance what the government already provides. And we put Sue in charge, again, his sister in charge of making sure that happens. Some examples of that might be, and I'm only going to use a couple of examples in the interest of time. A lot of times trusts like this are used to provide money for trips, excursions, vacations, etc. To enhance the quality of life of the individual that we're talking about, in this case, Robert. As has been mentioned before, I have an older brother with very significant autism. He lives in a very stereotypical, very well-run community-based group home. He has a better social life than I do. Although all of his basic needs are provided for, he has a very robust life within the limits of his disability. He's generally out to dinner a couple of times a week with his housemates. He and his housemates go away for the summer for vacation, usually to things like Ocean City, Maryland, or they've been on 2 Caribbean cruises with their housemates and staff and so forth. I guarantee, I can tell you with certainty, those things are not covered through government assistance benefits. My mom is able to make that kind of stuff happen for him. But when she passes away, a trust will be funded to make sure that those things don't go away for him simply because my mom has now passed away. So I will be able to dip into that trust as the trustee of that trust and continue to allow him to have the opportunity for a rich and robust life within the limits of his special needs. So, there are some restrictions. As I mentioned, you cannot use a trust in the money in the trust to pay for things the government already provides. But then again, that's sort of common sense. Why would you? For instance, as people age, individuals with special needs may need additional professional second medical opinions, durable medical equipment, alternate treatment or therapies, and so forth, some of which may be covered through government assistance benefits, some of which may not. You can rely on government assistance benefits to pay for those things that they will pay for, but the trust would be used to pay for those things the government doesn't provide, like better wheelchairs, supplemental aids and supports, as I mentioned, second professional opinions or alternate treatments and therapies, and so on. So if you kind of wrap your head around the concept that you use what the government benefits are, and you use them to their maximum extent, but then you use the assets in the trust to pay for everything above that or anything that the government won't cover. So that's your little nutshell version of what a special needs trust is and how it's created and what it does.
And that's why I'm so happy Paul's working with us, because now you can understand the scope and the importance of what a trust does, and in particular, what a special needs trust does. So let me go back to practical terms and we'll end trust on that. There's 2 things a trust does with that bucket. Number 1, it protects what's in it from outside sources. What are the outside sources we want to protect those assets from? Number 1 is the government. If you have a properly drafted special needs trust, it can have unlimited amounts of assets in it and the government never gets it. Even if your loved one passes away, the trust determines where those assets go. Other family, caretakers, loved ones, worthy charities, etc. But the government never gets it. The other side of that coin that Paul and I coach families on is unscrupulous people that would otherwise take advantage of your loved one with special needs. And this is where many families talk to myself if they meet me first or Paul and say, we're not rich. We're not going to do a special needs trust. We're just going to leave the assets that we want for Rob to his sister Judy. And we know that Sister Judy will do the right thing. As Paul always describes in his talks, those are gifts of moral obligation. Number 1, they're not legally enforceable. But number two, this is where people say, oh no, we know that his sister will always take care of him. Well, suppose the year after you pass away, that's when the sister spouse decides they want a divorce. Suddenly the assets that you wanted for your loved one with special needs become part of civil litigation. That is why a special needs trust is an integral item. What we will do is we will teach you how to fund that trust in the most cost and tax efficient way, regardless of where you are in life, regardless of where you are in your circumstances. The idea is to maximize your resources. So step 9 is guardianship. We've talked about it on a couple different occasions during this presentation. This is not to say everyone should, everyone shouldn't. It is a very individualized decision. The only thing I want to bring to this workshop, as Paul and I always discuss, is number one, it does need to be considered. And number two, it's not an all or nothing deal. So if we come back and talk about ABLE accounts and special needs trust and throw in guardianship, Paul and I can go through a lot of those things. But if guardianship is an issue for you and you're either beyond the age of 18 and you need help or you're approaching it, again, Paul's office is the place to call so you can make that very individualized decision in the most practical and professional manner possible. So let's say you've come through this presentation. You've either had some of these things in mind or you already had in your mind, yes, I know who I want to step into that role. So how are we going to try to ensure that that person that we're going to ask to step into that role, number one, can easily accept it, and number two, they can execute and do things the way that we would want them to do it? There are lots of different things that you may have heard of. We use an article that's called a letter of intent. As Paul will tell you, a letter of intent is not a legal document, but it has been used in conjunction with trusts. What a letter of intent is, if a will is your note and a trust is your bucket, your letter of intent is your playbook. It is what you would want to give somebody that you are asking to step into your role. Now, letter of intent could be a handwritten note. A letter of intent for medically involved families could even be videos on how to care for your loved one. In our organization, this goes back to my days with the MetLife Center for Special Needs Planning, we have a 38-page document. Now, I don't tell you that to get you overwhelmed. I will promise you 90% of what's in that document is in your head. What are your wishes? What does your loved one love to do? What do they hate to do? What are your thoughts on religion? What are your thoughts on dating? What are your thoughts on housing? Which doctors do you go to? Which places would you never go to again? And on and on and on. What we do in our organization is if we're working with a family, not only do we store that letter of intent in a digital vault, but every 2 years, we have a reminder, hey, did some things need to be updated? Paul made a great point. Your loved one may be a child or a young adult now, but when we're talking about what happens when you're gone, we're talking about a lifetime of care into things that change a lot with age. So a letter of intent should not be a static event. It shouldn't be an evolving document. But think about that process. You've walked through the financial process with us. You've walked through the legal process with Paul. Now you have a letter of intent where if we go back to that family meeting or whoever you're asking to step into that role, now you can know who you're going to ask to be guardian, successor guardian, who you're going to ask to be trustee. And an important point we always make is trustee and guardian do not have to be the same person. So as we come to the end, obviously we need both the legal side and the financial side. Too many times when we do conferences, people will come to us and say, oh, special needs planning, we've done that. And when we say, terrific, what have you done? They say, we did a special needs trust. And then the immediate question we'll ask is, what are you going to put in it? And a lot of times we see people thinking and they haven't really given it any thought. So here's what I want you to think of. If you go ahead and do a special needs trust and you do no other planning and you live to your life expectancy, what's going to go in the trust? Your house probably, and maybe what's left in your retirement plans. And while those assets could go into trust, they are two of the most inefficient assets to place in a trust. So at Special Needs Funding Coach, we will not only work with you on making sure that you get to people like Paul and establish the trust correctly, but we'll also help you understand what's going to fund that trust and help you be able to do other important things like retire and like have an estate plan for our other family members as well. So we've come to the end of our presentation. Paul and I have talked both sides of that coin. We hope we brought a lot of information to you. We want to leave some time for questions.
And we've got a lot of them, Don.
Okay.
There are plenty of questions. I'm going to
go right ahead.
Try to select from these ones that I think will benefit lots of people. Someone says, can SSI payments be put into the special needs trust? Are you saying I won't be penalized for having more than $2,000 in the trust?
So no, you will not be penalized for having more than $2,000 in the trust. Again, this trust, this cup that has, money in it or other assets in it, the government essentially, whether it's the Social Security Administration, Medicaid, DDD, or other government entities, essentially places an invisibility cloak over that trust. And so that trust can have more than 2,000, can have more than 200,000, can have more than $2 billion in it. And the government is not able to count that as a resource. You cannot, and I don't want to waste too much, or waste, it's not a waste, but in the interest of time, I don't want to expend too much time on this. But a trust that we're talking about cannot receive excess SSI benefits. You do not want to take your son or daughter's SSI benefits and put them into the type of trust that we're talking about here. One that's going to be funded when you pass away as part of your overall estate plan. One that is funded with devices and financial planning secured through Don and his team, where when you pass away, assets are going to flow into that trust. The type of trust we're talking about here is sometimes called a supplemental benefits trust, often referred to as a third-party trust, meaning the money is coming from someone other than you're a child with special needs. You can take SSI benefits and place them in a different kind of special needs trust, often referred to as a first-party special needs trust, sometimes called a Medicaid payback trust, sometimes called an OBRA trust. You'll go on the internet, you'll see all different terms. What that means, if you take the child's money, and in this case, SSI benefits that aren't expended, and you throw it into a first-party trust, you can do that and it's protected. It's just the difference in the type of trust that Don and I have been talking about all night. And as Don mentioned at one point in his comments, when the child with special needs no longer needs those funds because, he or she has gone the way of all living things, those funds can go wherever you want them to go. If you place money in a first-party special needs trust, when the child with special needs passes away, those funds go back to the government. The same can be accomplished, to go back to one of Don's earlier comments, the same can be accomplished with an ABLE account. Sometimes excess SSI funds that can't be expended or other forms of income that can't be expended are thrown into an ABLE account. And again, at the end of the individual's life, that money goes back to the government. The difference between a first-party trust and an ABLE account is in an ABLE account, you can only deposit up to $17,000 a year, and sometimes up to $22,000 a year, depending on the circumstances. In an ABLE account, a first-party special needs trust has no upper limit of its annual contributions.
Right, Brenda, maybe we should schedule that sometime in the future for that ABLE account special needs trust, because Paul doesn't want to, we don't want to go all night, but ideally, when we're doing planning, a family's going to have both an ABLE account and a special needs trust. We're going to teach you not only how to use that now, where if Social Security gets too high, we just funnel the money over, but also even when you're gone, as an efficient way to couple up what you do with your special needs trust. The administration and funding of those two accounts work in concert with each other, and the ABLE account has the ability to pay for things that special needs trust can't. yeah, the special needs trust can fund the ABLE account. So when you see that announcement, come back and see us again, because that'll be a worthwhile workshop.
Yep.
So 2 other questions I think that are particularly relevant. Can a grandmother's trust be set up for a grandchild? Can a grandmother's trust that's set up for a grandchild be combined or rolled into the parent's special needs trust?
Again, there's a lot in that. There's a lot of facts missing from that question. So, but taking it, what I think they mean and what I've seen before, yes, if grandma sets up a trust for the benefit of Robert, either before grandma knew she had, that Robert had special needs, or grandma didn't attend this workshop or otherwise consult with Don or myself, and sets up a trust for her grandchildren, or her favorite grandchild, and has her lawyer just set up an ordinary trust, and then grandma dies and funds that trust. No, you do not want to roll that trust into the type of special needs trust we're talking about here. You're going to have to roll that trust or reform that trust with court approval, more likely than not, into a first party special needs trust, which is subject to government capture at the end of the individual's life. The better thing to do, and this is what I do for my clients, I know Don does it for his clients, is to tell grandma not to leave a gift to a trust of her own creation, but to leave it to a special needs trust that's properly drafted. I give my clients, when they sign their documents, and I think Don does something very similar when we're working as part of a team, is we actually provide written language that clients can give to their parents and other family members. That says, look, if your family member is inclined to leave a gift for the benefit of your child with special needs, here is the exact language that your lawyer can plagiarize to make sure the gift goes where it needs to go and does not jeopardize government assistance benefits for their more distant loved one.
Mm-hmm. Mm-hmm.
Right. At the end of the day, you don't want the monies going directly to that person. You want it to go to the trust that's been set up for that person.
Right. The special
so
needs.
Many good questions. I'm going to wrap up with one that says, is all this state dependent? If I live in New Jersey or Pennsylvania or California, is the structure different? Does the language need to be different? If the disabled family member's in another state?
So the concepts are exactly the same from state to state. And the concept is applicable wherever you are. Some of the nomenclature, yes, is going to be different. There are some specific tax rules, and there are some specific planning rules that vary slightly from state to state. But the thing that is going to vary most, in my view, in my experience, are going to be the tax rules. Usually the estate inheritance tax rules are going to vary the widest. But the concept of using a trust to preserve federal benefits. Remember, we were talking largely about federal benefits here. SSI, Medicaid, which is federally funded but state administered. Every state has its own DD system, but they're largely the same in concept with some differences. So wherever you are, the concepts we've talked about tonight are applicable. I'm not licensed in any other state, so don't call me if you're in California. Don, I don't know if you practice in any other state, but
financially we're licensed all across the country. And the thing that we always say to families is, if that's a possibility, meaning, okay, we're setting up a trust, we live here in New Jersey, it's possible we're going to move, it's possible we're going to take our loved one with us to another state, clearly let your attorney know that. Or if we're working, we're going to make sure that we connect you to an attorney to the state that you're moving in to review it. Well, I'm sure Paul can do the same. The idea is the concept for federal benefits, which is the most encompassing, is the most important thing. We want to be able to support our loved one with special needs. We want to think, as you see at the bottom of the slide, a lifetime of care and a quality of life. And then the details from state to state are just different, as Paul says, rules and nomenclature, but the concept remains the same of making sure that you're looking out for your loved one with special needs.
Right.
Yeah, and
Well, go ahead.
Sorry, Brenda, and don't fall into the trap of saying to us, oh, well, my children are little, I might retire to Arizona someday, right? So I'm not going to do any of this until I retire and I know where I'm actually going to be. And you wind up living in New Jersey for the next 20 to 30 years, because that would be a very dangerous thing to do. You're better off, dealing with the circumstances that are in front of you, dealing with Don and his team in terms of setting up the funding structures that are necessary, and advisable to put into place. Because the sooner you do those types of things, the better legacy you can leave for not only for your child with special needs, but for all your children.
Indeed. Indeed. Well, we've got a raft of additional questions that we are not going to get to tonight. I will let everyone know that you will receive an email from the office of Don Brown inviting you to sign on to whatever kind of outreach material his firm puts out. So you'll learn about events that they might hold. You'll get an email from us with a link to today's program so you can watch it again over a cup of coffee or a relaxing evening. Maybe even you want to sit down with the extended family and go over this with them again. Begin that family meeting by watching this together.
It's great wine and cheese material.
Yes.
And you'll also be
Brenda,
added
two
to the
things, if we can throw it out. Resources that you can easily find are going to be valuable and the best ones. Paul's firm, their website is hinkle1.com. Hinkle, the number 1.com. Tremendous resources. Our website, as you can see on the screen, is specialneedsfundingcoach.com. Come back and visit often, but they're great places where you can have resources at your fingertips and then contact Paul's team or my team with whatever questions you have. From our perspective, if you fill out our survey and you want one of our resource folders, just give us a mailing address and we'll send you a folder. Special needs planning quiz, simple yes or no questions, overview of the process, the most common mistakes families make. The resources that are on Paul's firm's website are endless and they're updated all the time. So use those resources because they're easy to use and there's an abundance of information there.
The other point to make is that Paul's firm hosts hundreds of these events a year. And if you are part of a parents association or, your school would like to host a topic, the firm does that at no charge. And we appreciate both Paul and Don for bringing their expertise and their time tonight. I know I have benefited personally, and I know hundreds, thousands of families have too. So thank you both very, very much. Again, the questions continue to come in, but we are really beyond our time tonight. And hopefully next year when we put together our conference, we'll maybe allow a little more time for this one because this seems to generate a lot of questions.
Yeah, Brenda, I want to thank you for hosting in the Alliance. Yep. Paul, thanks again for joining me. I always appreciate your expertise.
Don, it's always a pleasure to present with you. Yes, Brenda, thank you and the Alliance for putting this conference together. And I'm glad that Don and I were able to clean up.
Okay.
Indeed.
Thank you all so much and good night.
Good night,
everybody. Good luck.
Good night.